Can we take a minute to take a broader look across all the variety of sectors and kinds of platform work? So not just on location, but also web-based platform work, to perhaps itemize or list at least top 3 or even more challenges that are being presented before regulators who are trying to ensure that platform work is decent work.
I think one of the biggest challenges is that of continuity of work and income, because this is something that is not there, because there's a huge volatility in both the work and the income earned. And to a very large extent, that comes out because of the kind of relationship that you have with the platform. So I think one of the issues that has been put up with the regulators is largely that, can we ensure the classification of the workers on these platforms as that of an employer and employee relationship? And I think that's very rightly put up, because if you look at any kind of a platform, it doesn't matter whether you're looking at location-based or you're looking at online platforms, you very clearly see that there is a technology that is actually allocating work, that is actually monitoring the work, rewarding the work, and at the same time, it also punishes you. So, you are in some way at the beck and call of a technology that is either a client or the platform. So there's a very clear relationship that exists as to how you should be going about doing your work. And if you do not have this basic work relationship defined, that has huge implications on your continuity of income, your continuity of work, and also on a number of other benefits, whether it is related to occupational safety and health or social security. And the third point that I'd like to make with this regard is there's absolutely no dispute resolution mechanisms that actually exists. So, if you're deactivated from the platform, or if you do not get your earnings, there's no mechanism per se that exists on most of these platforms where you can actually go and appeal and go about getting justice for it. So I think in all of this context, it becomes very, very important for us to look at the whole issue of regulations.
So let's use that as the start of a discussion about how governments have responded across the world. And more than that, from which angle they have approached these issues, because they cut across so many different regulatory topics, as it were, that the response has not been uniform, has it? So can you take a minute to clarify what has been the government's response so far across the world in trying to regulate these emerging issues related to ensuring decent work for non-standard forms of work?
The response from the governments around the world has been very diverse. If you look at European countries and you look at United States, the response has been much more with regard to whether the worker should be classified as an employer or employee. And depending on it, there have been certain courts that have gone with the judgment that, it is an employee or a worker. I think the Supreme Court case in UK last year was one of them, which identified the Uber taxi driver as that of a worker. There have been certain other jurisdictions, like in Spain, where they have gone about classifying the delivery workers as employees, but they have gone a step forward by asking for transparency in algorithms. While in other parts of the world, like, if you start looking at Asia Pacific, much of the regulation that has happened has related to work injury and benefits, or occupational safety and health, or social protection. Now, some of the Asian countries in Southeast Asia have also not gone about doing systematically for the whole country, but it has been much more regulations where they have worked out an agreement with a particular platform and gone about providing benefits for workers who work with that particular platform. In South Asia, we do know that in India, there has been a code on social security bill that has been passed, which covers platform workers. But I think it needs to be seen to what extent that implementation will go on. There are countries, again in Latin America, where issues around social security have been looked at. And the other issue that has come up in both Africa and in Latin America has been, and also Asia to an extent, has been around the issue of data. There's increasing recognition that we need to actually look at the issue of data protection, data privacy. So many of these countries are drawing from the GDPR that was developed for Europe, and then trying to modify and trying to see how that can be adapted within the country context. So, given the diversity that exists with regard to regulation and also the specificity that exists, whether it's based on the judicial decisions that have been taken, which is applying to a particular platform, it becomes very difficult for us to then say that, this is the kind of a regulatory response that it should be. And given the diversity, we have been arguing that there's clearly a need for international coordination to ensure that, there are regulatory practices that could be applied for workers across the globe, so that, there is not an uneven playing field that exists across countries or even within countries for that matter. I think as far as location-based platforms, probably regulating is far more easier than that of the online web-based platforms, where it is, talking about multiple jurisdictions. So, how do you actually enforce or put regulation? I think that becomes a big challenge.
That takes us to the next question, which is related to the potential role for regulation or convention that comes from above national level. So in Europe, currently, there is work being invested into the new Platform Work Directive being considered right now. And also from ILO's perspective, obviously, there's a number of conventions already in place, and then possibly a consideration of whether or not new ones are warranted. Can you take a minute to perhaps identify not just the value of international conventions, but also the clarity about how they relate to decent work, in the sense that much of this debate has focused on whether or not an employment relationship exists or not, whether a person is an employee or a outsourced subcontractor. But surely we can take a minute to say that some decent work standards apply to everyone, regardless of their employment relationship. So maybe we can take a minute to just highlight the relevance and applicability of existing ILO conventions and perhaps the space to come up with new ones.
I think all the 4 core conventions, and I think we have the 5th one that has been added this year, the Occupational Safety and Health, they are all applicable to all workers, irrespective of the employment status. It doesn't matter whether you're an employee or a self-employed. As long as you're a worker, all of those 5 core conventions actually apply to them. Then there are a number of conventions and recommendations that are not actually limited to employees, but they also extend to other workers, whether you're talking about minimum working hours, whether you are talking about peacetime wages, or accident injury. So it all depends upon, where and what it applies to. And I think you can see a number of conventions actually being applicable to them. And we bring this out much more clearly in our report.